very good evening and welcome this edition of the Fourth Estate. Charles Mongo Shampagi. It's been a week packed with activity, but the most important of them, or one of the most prominent, has been the Constitutional Court ruling sitting in Mbale on the Age Limit Act. If you can restrict it to that, but it was the Constitutional Amendment Act that removed age limits. The ruling, by a majority of 4-1, gave President Yoweri Museveni the all clear to seek re-election in 2021, seen as the major beneficiary. And like the Monitor reported, Museveni wins, MPs lose. Is it over? Is it over yet? What next is what we'll be discussing tonight. And we're asking the Constitutional Court ruling, the politics, and the law. What next? We already understand that, or maybe already aware, that one of the petitioners, Malay Mabirizi, has filed his intention to appeal. So an appeal is expected, but that will be part of the discussion that we'll be having. Also, it's a week in which we had elections for municipal councils, the newly created municipal councils, for the first time giving us a history-defining election. I've seen a lot of debate from Shema municipality, where we now have a member of parliament who is an elected member of parliament for a new constituency, but also still holding another constituency. The moment the gazette is out, I haven't checked to confirm whether the gazette is out, Dr. Elioda Tumwesije will be honorable because he has two constituencies at the moment that he represents. How will that be playing out? But more importantly, the election in Bugiri that brought in Asmani Basalirwa. Many people sympathized with Asmani Basalirwa, and many think this was just not a victory won for him by Bobby Wine, but also sympathy. He's contested in every election for Member of Parliament in Bugiri district since 2001. And finally, he's been able to make it. So congratulations to Asmani Basalirwa. But the most important question is, there's been all this banter on social media that the only constituency that the Forum for Democratic Change won in this contest was the WhatsApp and Facebook constituency, because it lost every other contestation we'll be discussing. Now let me introduce the panel that I have to help me navigate these rather complex issues. I have two lawyers on the panel. I have a political science lecturer, and I have a communications expert. He's done so many things.
He's a former journalist.
He's a former journalist. He's a former State House insider. He's a former member of parliament. He's a former editor, a former lecturer, so many other things. So let me start with Onapito Ekomoloit, Corporate and Legal Affairs Director at Nile Breweries AB InBev. Ona, always a pleasure to have you.
Charles, good evening.
We missed you last Sunday.
Yeah, I was a bit under the
He was not well.
Back,
Very good to have
And
you
we
back
prayed
in
for
good
him
health.
on the show last
oh,
Sunday.
thank you for the prayers.
I hope that wasn't caused by the anticipation of the ruling in Mbale or the elections on Friday for municipal councils. We have Senior Counsel Oscar Kihika. He's a former president of the Uganda Law Society and practices law with Kikan Company.
Biencha Chicken Company.
Biencha Chikan Company Advocates.
Yes, yeah.
Very nice to have you, sir.
Thank you very much.
We have Dr. Moses Kisa. Dr. Moses Kisa teaches at the State University of North Carolina.
North Carolina State
North
University.
Carolina State University.
Yes, yeah.
Doctor, very nice to have you.
Thank you, Charles. It's always a pleasure to be back home and especially to be here on the Fourth Estate. Good
And
evening,
last-
viewers.
Thank you. Last but not least, we have Silva Kayondo. Silva Kayondo is a PhD student, that'll be correct. He's a lawyer practicing with Otas.
Yes,
Yes, Otas Limited Liability Partnership.
yes,
Yes,
correct.
very nice to have you.
Thank you. Good evening, viewers.
Gentlemen, it's an all-male panel. We can't apologize much for that, especially given the time we have. We start this show, but we have a whole number of many female fans watching the show and waiting. So it's unfair to them that we hardly have representation from the female gender. But the question under discussion, I want to start with the lawyers. And I want to start with you, Mr. Kika. As a senior lawyer, this is a constitutional matter. You have a ruling on consolidated petitions over one act of parliament that where you're supposed to determine the constitutionality of it or not, that's what we expected from the Constitutional Court. And this Constitutional Court says part of this law is constitutional, part of it is not constitutional. How does that fit in legal jurisprudence?
It is not an uncommon phenomenon in legal jurisprudence. There's a principle of severability. Yes, I mean, the question that you ask is a pertinent one, in the sense that it has bedeviled jurists for quite a bit of a while. In fact, the judgment even quoted the late, great Lord Denning, who had to battle with the question, with that particular issue. But as he was rendering his decision that time, he said, look, to put it in very simple terms, it would be unfair to throw out the baby with
the bathwater.
With the bathwater. And so the legal jurists came up with a principle.
So the MPs were the bathwater.
With the principle that, you see, where one aspect of an act or one aspect of an affidavit or one aspect of a bill, whatever the case may be, right, is found to be legally palatable, that should be retained. And that is not conforming can be thrown out, right? And indeed, the judges of the Court of Appeal said, I think, who was it? I think it was the Deputy Chief Justice, if my memory serves right. He actually quoted an article in the Constitution which stated that, which proclaims, right, that all laws that do not conform with the Constitution are null and void to the extent, right, of their non-conformity. So in other words, aspects of that law that are constitutional remain, and those that are not constitutional are unconstitutional. So that encapsulates the doctrine of severability.
Yeah. Silva, I want to come to you because you're the lawyer here. You're the other lawyer here that we have in studio. This ruling was as much political as it was legal. And people have been looking to precedent and saying, look, how do you determine exactly that these aspects are constitutional, pass the legal test or the constitutionality test, and these aspects don't pass? When you have one package over a matter that has been so politically charged, where do you draw the line?
Yeah, firstly, I'd like to appreciate my colleagues for both sides. I felt that was a good attempt they did. I also wish, as a member of the Ugandan bar and also as an advocate, to also say thank you to the justices, because I think courts play a fundamental role in a democracy. Irrespective of the outcome, we've seen what has happened when we've resorted to settlement of political dispute by other means other than through court process. So I place my thank you on the table. Concerning your question, in my view, there are two principles that we need to look at regarding your question. By its very nature, the Constitution is largely a political document. It settles, it defines what the relationship of the citizens is with the state and that of the state with the citizens. And the politics is at the interplay in there. You have elections, you have matters of judiciary, you have matters of separation of powers among legislative function, and then the settlement of disputes there. So that's one. Then two, there are two practical issues at play when you come to such a settlement. And you have the principle of judicial activism and then judicial restraint. Now, judicial activism, some have posited that it's where judges rule in accordance, say, with political persuasion, rather their own view, rather than the law. it's been criticized largely because judges are not elected representatives of the people. They are appointed and then they exercise in this jurisdiction, that is. In other jurisdictions, judges can be elected. Then you have judicial restraint, is that principle where judges or judicial officers are required or exercise a certain sort of restraint in matters of politics. One variant of that has come to be known as the political question doctrine, PQD. I'll give two live examples. The first, of course, the judges have referred to the history in 1966, ex parte Matovo, with the introduction of Hans Kelsen theory that if a government is successfully overthrown, then you have a new constitutional order in place and the other government
And the other one has been overtaken.
Been overtaken. But also recently in Zimbabwe, when President Mugabe was dethroned, some applicants ran to court contesting the act, what the military had done there. The judge said the intervention at the time was required for two things. One, to stop a political vacuum that was going on in Zimbabwe, but also President Mugabe had abdicated his responsibility by having the First Lady continuously run the affairs of the state. That was the judicial reasoning then. So judicial reasoning...
You always ask as a lawyer, was that good judicial reasoning or not?
So I cannot go into the details of whether that's good judicial reasoning or not, because just like biblical theologians can disagree on the interpretation of the Bible, same text, same canon, so is it with lawyers. There is no uniform answer in interpretation of law.
That's
If it were there, then we would never have disputes. So we go just because there's been a variation in interpretation, and that's why you can quote a 4-to-1 majority.
Okay, thank you. Dr. Moses Kisa, if you could just indulge me for a moment,
sure.
and Honor, let me just go back to Oscar for a moment. This is a country struggling to build constitutional democracy. And to the interpretation of many, some of these actions are ripping pages out, especially the legislative part, not the judicial part, ripping pages out of that constitution. From, you could take it back, he takes us back to 1966, the ex parte Matov case.
Yes.
But you could take it in recent judicial legal history. You take it back to the 2001 election petition, 2006 election petition, 2016 election petition, when something called substantiality gets introduced. That this was not an election petition. The arguments largely by the 4 judges that ruled would be interpreted in the same way as determining the substantiality of the non-compliance with legislative procedures to arrive
rules of procedure.
Rules of procedure to arrive at this act. What does that mean for the building of constitutional democracy?
No, I think let us make. Let me make one thing clear. The question of substantiality does not apply in these circumstances. With due respect, no. The issue of substantiality is strictly speaking restricted to matters of election.
No, I'm just borrowing the word. I'm just borrowing the word to create parallels with this particular ruling, because you're saying that in as far as the clauses on the extension of the term of parliament of members or the term of parliament and local governments, you acted outside of the constitutional provisions. But in as far as passing the clauses on the removal of age limits, you were compliant. I'm borrowing the English word, not the legal interpretation of substantiality.
Okay.
Yes.
Okay. Now let me explain one thing here. You see, and I like to make things a little bit simple for the public, so that we're not talking to each other. What that judgment was saying, if you read it, and if you read the Constitution, it was discussing 3 types of articles right, which have been subjected to amendment, right? And they fall in three classes. You have those articles which can be amended by a referendum. Those are said to be entrenched articles. You have the second category of articles which can be amended by, is it local district councils? 2/3, right? Those, again, are said to be entrenched. Then you've got a third category of articles which can be amended by parliament.
2/3 majority.
Two-thirds majority. It's a simple majority of members of parliament. Those are said not to be entrenched. Okay. Now that is where the distinction comes in. Why they declared the passing of articles relating to extension of the parliamentary term from 5 to 7 years, and the local council from 5 to 7 years, then the reintroduction of
term limits.
Term limits was that the procedure for that amendment would have required a referendum. That was the category, and that's why they declared that aspect of the act unconstitutional. When it came to the lifting of the age limit, the Constitution itself provided that that amendment can be passed by Parliament, and therefore, to that extent, one can say that was not entrenched. Okay, that's where the difference is. Of course, other people have, as you can see even from your question, have misunderstood that to mean, right, that substantial. They're relating the substantial argument in this particular instance. Now, when it comes to the particular question you are asking, with regard to, and this is where there is a debate, and this is where perhaps we wait to see how the Supreme Court is going to handle this disagreement. On the one hand, 4 judges were saying that in the passing of this amendment relating to the lifting of the age limit, okay, not all the parliamentary procedures were followed. Not all of them.
Not all of them were followed, yes.
Yes, not all of them were followed. And particularly with regard to, I think, the consultation process, okay? Justice Kakuru, on the other hand, said, look, the consultation was really not a consultation in his view.
There was no consultation. And
therefore, he declared that amendment unconstitutional. So this is a question of now, I think, if it's a question of they recognize the fact that, look, I think it's a question of application of the facts, right, to the law. I hope I'm being...
Yes, I'm picking you. And I'm only wondering, and I want to draw in Dr. Moses Kisa here. When you have a matter, a constitutional matter that is as much political as it is a matter of law, and in this case you have a dissenting judgment from one of the lawyers, from one of the judges rather, we have seen where a single dissenting judge carries the day on appeal. And you quoted Lord Denning. He was a contrarian in most of his rulings. He disagreed with a convention. How do you place the two together? How do you, where does the politics stop? Where does the law start in this matter?
Charlie, I think the one issue that you were alluding to, which Oscar hasn't addressed, is, and which I think Justice Kenneth Kakuru was underlining, is that the whole law, the act, was passed under an environment that was dubious, that was irregular, and that was unacceptable, right? The manner in which the age limit provision was handled was in an environment that, contravened the Constitution and the rules of procedure, right? And that if you're going to annul sections relating to the extension of the term of members of parliament, in this, Omnibus Act, you have to annul the other sections as well, because the whole process was littered with irregularities, with wrong acts that included, Parliament being under some sort of siege. There were reports of bribery and underhand methods. Okay, so if the entire process of the constitutional amendment had question marks around them, at the end of the day, it's a little bit contradictory to say that one thing should pass, but the other thing shouldn't.
You're reading the mind of Nteja Sime, because he says he's put a question to Silva and Oscar, and he says the Constitutional Court judges unanimously said the process wasn't entirely clean.
Right.
Agreed.
Yeah.
However, this unclean process could only invalidate the extension of MP's term,
but not
from 5 to 7, and not the lifting of presidential age limit. Do you find this contradictory?
Which I think is what he was alluding to earlier when he drew parallels with the idea of substantiality. Remember, in the past, the Supreme Court has argued that, okay, wrong things were done, but they were not as grave as to undermine.
But
you see,
my mouth dries.
Please forgive me. Yes.
Look, I think anybody out there listening, of course, knows that we are trying to split hairs here, to use the English words. The question the judges were wrestling is what you said at the very beginning. Is it all lost for Yoweri Museveni's opponents? And I tell you, it was lost in 1986. So all this is going through motions. Yoweri Museveni is not a creature of the 1995 Constitution. On the contrary, that constitution is a creature
Of Yoweri Museveni.
of Yoweri Museveni. He came to power and put in a process to evolve that constitution, essentially to help him administer the country, not to determine whether he should administer the country. So all these motions, and the judges, remember how delayed this judgment was, the point that somebody went to court to cause it to be read.
Be delivered.
Precisely because the judges were wrestling with the question which every Ugandan is wrestling with, and which have insisted, what do you do with Yoweri Museveni, who is a factor of life in Uganda?
He's above the Constitution, in
And
other words.
Of course.
So then why does he
Judges
overthrow the
don't-
Constitution?
I mean,
No, if you listen to Honor, he's saying the Constitution is a tool.
For him to use.
That
remember,
helps.
the president in the last New Year's message was very categorical. He said he thanked members of parliament for having made it easier to lift age limit without using other complicated means. These judges were in this town. They listened to him. So, I mean, I think the judges were in sync with the population. Because, okay, after Parliament passed the resolution, there was no uproar in this country. After the ruling in Bali, there was no uproar in this country. It tells you something, that the population, which Yoweri Museveni used in his words to come to power, somehow says MPs, that's why MPs are voted out over time and again. In the same constituency where the president wins by 100%, MPs get defeated. And he stays, yet government is one. So how do you explain that logic? So we can split hairs here and say the law, this was about deciding whether the president should continue in office if he wishes beyond 2021, and the MPs, we can remove them.
Honorable, let me ask you, how do you reconcile what you are saying with the fact that generally the popular view out there among the Ugandans is that Yoweri Museveni should actually step down from power? It's you know, if you look at the successive opinion polls about support for term limits, okay, the vast majority of Ugandans want term limits to be restored. Even in this age limit consultation, countrywide, everywhere MPs went, or at least the majority, if not most of them, the public opinion was that the age limit in the constitution should not be removed. How do you reconcile that with your assertion that the public out there somehow has been captured by Yoweri Museveni and they want him to stay on for as long as he wants?
Do you want to respond to that?
No, I meant my point, telling you, you are trying to understand why the judges were conflicted in finding that the MPs wanted to extend themselves irregularly. And they quoted history extensively. They were so, just hold on, they were so charged. They almost ran out of words to describe MPs. But the same president
say anything
who was
about
working with the
Yoweri
MPs closely, they somehow everything was okay.
And let's come back to Chika and ask, how do you reconcile that? Because Justice Kakuru labored to summarize Uganda's struggles with constitutionalism to arrive at where we did. And how would it get lost on the judges that this constitution they were interpreting and trying to align with the new law has been changed at the convenience of
one individual.
One individual.
Yeah.
Excuse me.
Yes.
You know, I hate it when, and I mentioned it earlier, I hate it when you have intellectual dishonesty when looking at when discussing issues. I carefully listened to Justice Kakuru's judgment, and the theme of his judgment when he was going through the history of this country was about lack of consultation with the people. That was the theme of his judgment. Okay? And in arriving at his decision, his quarrel with the process was the fact that this amendment had been carried out because there was not enough consultation with the people, which was an essential, one of the essential reasons, right, for his throwing out all the amendments. That is what the basic theme of that judgment was. Not all the other issues that you're talking about, right? Yes, there was a bit of discussion about not following
the rules of procedure.
The rules of procedure. But as far as Justice Kakuru was concerned, and I take his point, right? His quarrel was that, you see, this amendment did not, there was not enough consultation, and yet, and therefore was contrary to Article 1 of the Constitution.
Right.
Which
Power belongs to the people.
belongs to the
And
people,
he also emphasized
right?
that
Okay.
MPs are delegated by the people.
Exactly.
They don't represent
They don't
themselves.
represent themselves.
Yeah.
So that was his quarrel. That is what it was.
So is the dishonesty in this case?
No, I mean, when they were talking, saying that it's because it's Museveni thing and stuff. No. That's not what the judgment said. All right.
He doesn't have to say.
For me, if you're asking me to discuss the ruling, I discuss the ruling as I read it and what I see. If you're going to make your implications and political, that's your business.
We frame our topic to look at the politics and the law and to ask what next, because you cannot discuss this as the law without discussing the politics that it impacts.
I take your point.
It can't be in a vacuum.
I take your point, right? Because you asked me about the thinking processes of the judges. See, the judges look at the law. That's what their primary role is. Look at the law, interpret it, and then apply the facts to it. That is how we look at things. Now, it's up to the public. After that, you asked about what are the implications thereof of their decision, okay? Because you're quite rightly said that decision has got a social, political, and perhaps socio-economic impact. Those are two different, separate things. Now, going back to your question, which is pertinent, and which is what I'm trying to answer. So, given what Kakuru had concluded, observed, and concluded, how is it that the other judges had a different
Oscar, can I ask you something?
opinion?
Can I ask you something?
The simple answer to that one.
Yes.
The simple answer to that one. Actually, you know, judges or judgments at appeal level are, in other terms, called opinions. Judges render opinions. Okay. So what happens is that
They had their own
they had their own.
But the opinions ought to be based on fact and law. They can't just
and
be
interpretation, like my
Right.
learned brother had said here. You see, you cannot have a homogeneous manner of discussion or discourse. Okay, they come with different.
I hear you, but you see, legal history, especially on these sensitive matters, is littered with where the politics shapes the opinion of the judge. And that's what we're struggling with the Ugandan constitution. Because if you look at the amendment of the term limit in 2005, same argument, what Ona has been saying. President Museveni and the National Resistance Movement shoot their way into power in 1986. In 1987, they think, no, wait a minute, we need to frame a constitution. And they put in motion means to generate a constitutional draft, a draft constitution. 1994, we have the Constituent Assembly. 1993, 1994, you have the Constituent Assembly that generates this constitution, and it enables President Museveni, after 10 years in power, to seek election as an elected leader in 1996. 2001, it becomes an impediment. And you think about creating amendments. Changing it. You change it in 2005. Shortly after, there is another impediment. You come to look at that. Are you still dealing with the law, or are you trying to manage the law to suit particular interests? And what kind of pressures were these judges working under, or what kind of history did they inform themselves with before getting into the opinions that they generated at the end of the day? We'll pick this discussion up after a very short commercial break. You're still watching The Fourth Estate, and like many other Ugandans and people the world over are struggling to understand and interpret the ruling of the judges. Oscar, have you been able to read all the over 800 pages? 814, I think? 814. About 14 pages of the consolidated ruling.
I'm still analyzing it.
Well,
I took notes. In fact, I have them here.
Yes.
Each and every salient one.
Salient one.
Yeah, well, I read the full judgment in extenso. I took off time yesterday. But on the question you asked, really, the Constitution is what people largely all over the world consider as a tenet of democracy. Now, in analyzing that, you have to look at four things if you're to come to at least some semblance of understanding the factors that were at play in that judgment. One, you can look at the Constitution or democracy as a procedure. The rules of procedure, if the bill has gone through the first, second, and third reading, the MPs are elected representatives of the people, then it goes through. It flies. You can look at the Constitution.
And there are regulations or rules within the parliamentary rules of procedure on how you do the first reading, how much period you need to allow before you go the second reading and the third reading.
Then you can look at the Constitution or the democracy as a form. If as long as you have a judiciary, say legislature and executive, then you have the core tenets, and of course on the assumption that you have periodic elections. You could look at the Constitution or democracy as a substance. Here it's what I think the judges tried to do in enunciating what they call the basic structure doctrine. So I'm a law teacher, so I usually tell my students sometimes that the Constitution is like a human being. It has a skeleton onto which all these other parts support. So in this case, you saw the judges trying to wrestle with what that skeleton is. For instance, the Article 1, sovereignty of the people, it's on the above basis that the MP's extension was quashed. They went to Article 2, which is the supremacy of the Constitution, because the Constitution is not any other ordinary law. And then they went to Article 3, which forbids coups. Of course, it's informed by our history from 66 and onwards. So that contestation of ideas there is what probably informed some of the judicial perspective you see it. And then lastly, you could see as the Constitution or the democracy as a numbers game. We had the majority, the poll was called, members voted, yes, the yes side had it, and then the matter is closed. But what Justice Kakuru went into, actually his judgment, he even listed the groups and individuals who were consulted, and he found it was only about 0.02 of the population.
Yes, 22 in total.
So for him, he went beyond what is the procedural and delved into the substantive elements of what really entails a public consultation, and which you see that variance was not carried in other judgments. And I think that largely informed the kind of decision that he arrived
For me,
at
I
the end of
think,
the day.
just to emphasize my point, the judges looked at the day after. Do you want, whatever they were actually reading history, talking about constitutional crisis, do you want a constitutional crisis? You are dealing with a real situation in Uganda, which is unique to Uganda. This is not even Kenya. It's not Tanzania, you know? And if there are stated political positions that are so strong, and they are backed by sections of the population, they are backed by the armed forces, because the armed forces was one of the major elements in this discussion, whether they could actually go to parliament and did what they did, and somehow the judges even accepted that they were justified, though they used maybe excess force. So all these factors were there. I know the judges may be listening and thinking for them they were purely interpreting, but I believe these are ordinary Ugandans.
Before you go to the judges,
some of them,
Oscar is seated next to you, and his argument is
they are
strictly
really political
the law.
players in Uganda.
Look,
Remember, in the most, people think the most advanced democracies, the US, the role of the Supreme Court is so political. You know, the biggest debate is when Trump has appointed 2 judges. So when the president has also been said to have influenced the appointment of some judges because of their political leanings. So these are human beings. And I think they looked at the reality of the Ugandan situation. So what if you said the age limit removal was unconstitutional? What next?
I'm just wondering, actually, Oscar,
You must ask this question. What
at the
next?
application, the application or the usage of Article 1, power belongs to the people, in the manner in which it was used on these 2 very controversial clauses within the Act.
Yes.
One is the clause on the removal of age limit, which concerns and, for all intents and purposes, benefits or would affect one individual called President Yoweri Museveni as of this time, if you're looking at the Constitution as it is.
Yes.
And the one on members of Parliament, which is for the group that is in Parliament at the moment, and local government leaders. How do you reconcile what it talks about as power belongs to the people, Article 1? And I want to read you I want to read for you something that Julius Bargaba quoted in the East African. This quote from which Onapito referred to, from President Yoweri Museveni after garnering the victory in Parliament. I want to salute the 317 members of Parliament who defied intimidation, malignment, and blackmail, and opted for a flexible constitution to deal with the destiny issues of Africa, instead of maintaining Uganda on a path of unimaginative, non-ideological, non-colonial status quo. By doing so, they enabled us to avoid the more complicated path that would have been required. And everybody will be asking, what are these complicated paths that we're able to avoid, that the judges could possibly, the majority of the bench, could possibly have been trying to also avoid?
There are 2 questions there that you're
Yes.
asking me, Charles.
Yes.
And I'll answer them. Okay.
Please go.
The first one, you see, which talks about, which relates to the issue of the manner in which the power belongs to the people, etc., and how that article was declared unconstitutional. Thing was, and you see, the judges were battling with something rather basic here. You see, with regard, if you recall, I'd said that there are certain articles which can be amended by an act of parliament, right? Now, when it comes to the passing of an act of parliament, right, there's a special procedure. A bill is presented to parliament, then there's a period of how many days? 45 days for consultation. And then you go back and present it for the second reading and the third reading. Yes. Now, it says that those articles can be amended by presenting a bill of parliament. Okay. Now, this is what they were fighting with. On the one hand, 45, that's what the law states. To pass a bill, you need 45 days for consultation. And yet, this is a bill for the amendment of a constitution. Obviously, 45 days is not really, strictly speaking, it's not enough. Okay. But they said, look, the 45 days, the four judges said the consultation was held within the 45 days. But they were at pains to make recommendations for the change of the law with regard to the presentation of bills which relate to amendment of the Constitution. Why? Because those recommendations related to that difficult question of the 45 days consultation. Justice Kakuru, for him, was saying, no, it's not enough. Not enough consultation was done, and he declared this it's unconstitutional. So you can see that's. I hope I've answered the question there. That's what they were grappling with. Now, to come to the second part of your question, what you've just quoted was about the alternative.
Do you want me to read it again? Please, I'll be happy to. I'm happy to read it again.
And it will be a requirement, not a possibility.
I'm happy to read the entire quote again. I want to salute the 317 MPs who defied intimidation, malignment, and blackmail, and opted for a flexible constitution to deal with the destiny issues of Africa instead of maintaining Uganda on a path of unimaginative, non-ideological, non-colonial status quo. By so doing, they enabled us to avoid the more complicated path that would have been required.
Now, that is where I defer now to.
If I might chip in there. Yes. The president, I think, in my view, the president makes quite an important distinction, because constitutions fall in. Broadly speaking, of course, you have the written and unwritten, but you also have flexible and inflexible constitutions. Uganda is not the first country to amend the constitution. I know, like, the Indian constitution came into effect in 1950. It has had 101 amendments. The US Constitution, I've carried a copy here, given to me by the Cato Institute in Washington, D.C., is very many pages smaller than the Ugandan constitution. It came into effect in 1789 and has only been amended 27 times. The South Africans have had 6 constitutions. The one they have now, which is the 1996 constitution, has already been amended 17 times. Uganda's has been amended 6 times with about 65 amendments. So there is really a dynamic at play which is quite interesting from a comparative perspective. But what makes Uganda's case peculiar is that these amendments have always come at a time when they've sought to put a stop, say, on, and I'm not really discussing persons or something, but you saw.
But why not? Why not?
No, I mean,
why not? No. You see, a country has persons, it has individuals, it has leaders, it has people with interests. Okay, so we cannot be talking in abstract terms. We have to speak to the realities. You see, when Peter was talking about the realities, you are saying the Ugandan constitution has been amended fewer times, but how and why has the constitution been amended? You're talking about the Indian constitution having been amended so many times. Why was the Indian constitution amended? The Ugandan constitution has been easily amended to serve the interests, the whims, aspirations, and machinations of certain individuals. In this case, the constitution is being undermined because one individual wants to be in power forever. This is the most important issue that confronts Uganda today, and we have to face it.
I just wanted to add a small question to your explanation. I'm happy to listen to you continue with the explanation. Why interpret this flexibility only in regards to the presidency and not the members of parliament? Don't you want that flexibility everywhere?
I don't know, but that's really taking a very narrow view of the constitution, in my view. For instance, I'm aware that some of the provisions have emanated from Uganda's peculiar needs. If you look at that constitution well, I'll point, for instance, to like Article 77.4, which deals with state of emergency and how Parliament can extend the tenure of the president during that time. It is informed by 1966 crisis, when Obote attacked the Lubiri and then overthrew the constitution. And from 1966 to 1971, Uganda did not have an election as a result of a state of emergency. Another article you could look at is like Article 92, which bars making of laws that contradict court judgments. That's also informed by the ex parte Matovu case, because after Matovu was given a habeas corpus, produced the body, Obote immediately went and recycled, and they brought legal notice for 1966, which again they were arrested and then deported.
Thank you very much. I think you raised something fundamental.
Yes.
When do you also look at the former Article 102B? No, the former Article. The former Article 102B,
yes,
which was amended,
yes,
and former Article 1052.
Yeah, so I will start with Article 102B. I have had the chance to look at the Constitutional Commission report, specifically on page 230, where the age factor comes in. There, I did not find basis for why, say, 35 years was the minimum age. I could be president of Uganda, but also 75 people suggested 70, which was interpreted as barring Obote at the time, because Obote, having born in 1925, would have been 70 years old exactly in 1995 when the Constitution was enacted.
And the framers of the Constitution, which is the argument that the Mayombos and other people were making in the Constituent Assembly, was that, I mean the explanation that we got later, not the record of the Hansen, that there was a fear that Obote could come back and would be eligible to stand. So put a bar. Now, when it comes to a time when Museveni is about to become ineligible,
then we have to be
flexible.
Then we have to be flexible.
Then you create the
and also, can I just quickly say this? Can I just say this? You see, we're talking about the peculiar history of Uganda. You are not talking about the peculiar history of Uganda in respect to the fact that this country has never had peaceful transfer of power from one president to another. The reason why those two provisions were put in the Constitution in 1995, the term limit and the age limit, was precisely because of the country's history. So when we talk about flexibility, and I'm glad you were talking about history and peculiarity, we should also be thinking about where has this country come from in terms of leaders who don't want to leave power, and instead they have to be chased, and the country descends into chaos.
This country has also not had the experience of a leader dying in power. So you can have all those experiences. There's no one. But I wanted to say,
you want to experiment with that?
My former boss, Yoweri Museveni, is solely
who you still love so bad.
He's solely to blame for this. He's the equivalent of a traditional polygamist who also decided that he wanted to wed without letting go of his other wives. When he came to power, parallel with the Mao and all these revolutionaries, with the titles of chairman of the High Command, and all these titles which he still has, which is the real source of his power, the temptation to appear liberal Democrat
and democratic.
And then going
remember in 86 on Apito, he said, I want only 2 years.
So at the height of this age limit removal, I had with some people close to the president, and my argument was consistent that you can retain Yoweri Museveni, whom you never had to bother with the constitution to bring to power, and still have this country move forward. And the country needs to deal with that issue. That assuming he gets away with another 30 years of life and he's still in office, people are not agonizing over because he's in office. They're agonizing over the deficiencies brought about by that. How do you cure those deficiencies alongside having him in office?
Okay.
That's what the country needs
I'm curious to listen from you after this argument. Yes. Because you need to place the legal into the political reality. The Constitution of Uganda does not exist in a vacuum.
No.
If you want
so the interpretation cannot be done in a vacuum. And that's what the court was struggling with on Thursday.
You see, if you want to do that, you ought to listen to Onapito very, very carefully.
I am.
Okay? And to my friend, and others who think like him.
On the panel here, I'm a lone voice. In some
not
ways.
a lone voice.
The three of you are reasoning in the same direction. Somehow this was a good thing. Yoweri Museveni should continue ruling us until he dies.
No, we haven't said that. That is
Implicitly.
you're putting words in our mouth.
Implicitly, that's what you're saying.
But you see, you've got your head in the cloud without feet on the ground. Let me tell you something, right? In law school, we were taught a subject called political economy before we got into the deep vestiges of the law.
And I happen to teach that.
We learned that the law is a reflection of society at any one specific period of time.
True.
Okay?
True.
Now, what you have got to understand, and you keep on saying this correctly, that our constitution, currently as it is informed by our history.
Correct.
Right? Now, most times, people go and start interpreting our constitution, applying political issues
out of context.
Out of context.
Yeah.
Actually applying other experiences, right, from other jurisdictions and trying and applying them here. You can't do that because the values and the norms, which Peter, by the way, is at pains trying to explain, is what is seriously on the ground. So the question that we've got to be grappling with, and from a legal standpoint, is how can we push for true democratic values, okay? But which values, by the way, right, are allegedly universal, right? But in the circumstances of Uganda. And not in the circumstances of Uganda.
And tailor them and apply them to our circumstances.
So the thing is this, the question that we should be asking ourselves is that, are we trying to impose on ourselves a democracy that really is not applicable to us here?
Charlie, can I say something?
I'm not sure that's what
that's the question we should be asking ourselves.
Maybe that's a question. But Silva here talked about form and substance. And Ona puts it very well. Why do you as lawyers want to take us through motions of assuming an ideal that we are interpreting a constitution, we are working under a constitution, when the reality is, as he said, that on the ground, this constitution, the constitution as we have it, and very many critics have said this when I talked about that substantiation because of those other interpretations, other questions that have come up, that this constitution is only inconvenient at particular moments and to particular individuals and convenient for the legal explanations that the lawyers seem to be making.
Can I answer that question?
Please do.
I think it was answered very well by His Lordship Justice Cheborio. He has a quote in his judgment, which, while quoting Julius Nyerere, says, you see, the Constitution is not supposed to be, the people are not the ones who are supposed to serve the Constitution. No, the Constitution serves the people.
How do you reconcile that?
Now, now you see, the thing is this. Building up from that is where we come to Onapito's theory, but explanation here. You see, currently as it is, like it or not, what Onapito has just said is correct. People are very uncomfortable with having MPs, constantly in their faces, so they will change them from time to time, right? But they want a certain constant who's Museveni. Those of you who like it,
which is not necessarily true.
How do you reconcile that? How do you reconcile that? We're talking about the same constitution.
Yes.
How do you reconcile that with repeated Supreme Court rulings that have raised significant questions about the quality, the manner of the elections that we have held for that constant that you're talking about?
And can I
how do you fit that in?
Charlie?
Well, and the thing is this, and the thing is this. Has the right question been asked about whether the people are not comfortable with it?
That's the question.
But Oscar,
those
why?
Things the judges find to be wrong are being perpetuated by people.
Oscar,
Yoweri Museveni sits in Rajasthan, and then a bunch of people across the country are doing those things.
If the constitution is supposed to serve the people, Oscar, okay, let's go with that, right? Justice Kakuru was saying, if you are going to change the constitution to serve the people, consult them, all right? Let them say, change the constitution like this and that, which was not done, right? So, doesn't it then follow that the whole process leading to the change of the constitution to serve the people was done without the consent of the people, and therefore it is null and void?
No, that was a question of fact.
Yes.
That was his interpretation of the facts.
But was the consultation actually done?
No,
it wasn't.
That's your opinion.
No, not my opinion. It's a fact.
No, excuse me. That's
It
your
is.
opinion.
It is a fact.
No, excuse me. That is your opinion.
It is not my opinion.
The opinion of the other judges was that.
Consultation could
No, actually.
What evidence?
No,
What
no,
evidence
no,
did they
no,
present
no,
for
no,
that?
One of them
No,
is they
no.
say that during the final debate, opposition MPs like Bobby Wine were saying they consulted, and people were saying do not.
No,
remove.
actually, no. One of the limitations the current constitution and the rules of procedure have is they do not enunciate what amounts to consultation. And if you're to read the recommendations of Justice Remy Kasule, he points out that actually Parliament should come up with a basic guideline on what that consultation is. In fact, he recommends that Uganda Parliament should look at Kenya and South African experiences on consultation. Kenya has an entire elaborate
goes back to the same question.
But also what the point I'm making is, and actually, to give you a live case, as a petitioner in the OTT tax case, we are also exploring how consultation, say, before bringing mobile money tax and this was. But also we need to move away from that notion entirely that the constitution is largely a historic, or we need to, it's also a prospective or futuristic document.
I think I will agree with that, but I think it's really a romantic and ideal notion, really.
Isn't this whole debate about whether this is a constitutional democracy or not, and the process we went through leading up to the ruling on Sunday, on Thursday, isn't it actually a romantic notion in itself?
It is, and Onapito
we'll pick this up after a very short commercial break. We'll be right back.
Onapito has said we are under a military occupation.
It's a constitutional monarchy.
Now,
as we take the break, you need to look at this from that perspective and ask, what are we romanticizing about having a lot of argument about constitution? Does that constitution actually function for who?
There have been live cases.
Let's take a break, gentlemen, and we'll come back into this discussion.
for you, I don't.
Interesting debate on, especially.
I know these things a little better than you.
With my panel. Gentlemen, we're running towards the end of the show. Let me take some feedback from some of our viewers. If Mr. Onapito Ekomoloid was not selling beer as his day job, I would buy him a beer for his realistic appreciation of Uganda's predicament. Everything about Uganda, including its history, is supposed to be understood to begin with Museveni and NRM in 1986. All other things, including all the constitutional amendments, follow that path or help to make that path smoother and its destination clearer. This is a message from Nicholas Sengoba. Levi Zache. Silva Kayondo talks about peculiarities of Uganda as a country determining the judge's decision. When do we get out of that trap? The 1995 Constitution, as stated in the preamble, was trying to deal with the peculiarities of our history. How about the 2005 amendment? And how about this 102, Article 102B amendment? Are these new peculiarities? What has perpetuated the current peculiarities, 2005 and the current amendment of 102B? That is Levi Zache. Josia in Intinda. The Constitution is fatally flawed because, whereas it is firmly rooted in the history of Uganda, its spirit lacks alignment to a future of good governance and development. It does not address the absence of civic maturity within the population as the major reason for a dark history and its role as the critical guarantor of constitutionalism. I'd like the lawyers especially to ask whether this constitution as it is and where you're placing it becomes a guarantor, is a guarantor of constitutionalism in this country. That's a question from Josia. I don't know if I have permission to mention the name of the person who sent this message, but I'll read it. Charles, the question you asked hasn't been answered. What did the president mean by the more complicated path that was avoided?
He was threatening a military coup.
I'd love to hear what Kika says about that. And I have avoided the name of the person who sent that message on purpose. If they send me a message and say it's okay, you can mention the name, I will. This is Rama Omonya. He says, the majority justices faulted the petitioner's arguments that there is no clear format of consultation that was... Yes, the majority justices faulted the petitioner's argument that there is no clear format of consultation was short-sighted on their part. The making of a constitution is a very consultative process. The amendment of a constitution is, in essence, a constitution-making process. The parliament sitting to amend a constitution should not be treated as a parliament making or amending an ordinary law.
Right.
Even in absence of a clear law defining consultation, the justices ought to have addressed their minds to this unique amendment. This is the reason why the Constitution provides for a constitutional review process to inform amendments, especially where an important provision like Article 102B is concerned.
Controversial.
I also agree absolutely with Onapito. The President has ever said to the Constitution, referred to the Constitution as a mere piece of paper.
Charles.
Can I finish?
Just one thing, because I might lose.
Okay.
I just want to answer the last contributor there. You see, with regard to that, to Article 102B and all that, when they were talking about, the Constitution specifically provides that to amend that article, right, you have to pass it by presenting a bill to Parliament, and then they refer you back to Articles 75, which says says bills of Parliament are to be treated according to how Article 75 prescribes. So so in those circumstances, the Constitution ties you in. You cannot, the judges cannot go out of that, and that is why the judges were at pains to make recommendations on how to deal specifically with those bills that are mentioned in Article 260. Right? That's a point.
Could you also answer the other question? What was it? There was a gentleman here who was interested in hearing your answer on the question I put to you.
Oh, yes.
Those complicated paths.
And
you need to tie those complicated paths into the preamble to the Constitution and what Josia was asking.
The complicated path, where everybody's here, it was a very simple one, right? The complicated path made the more costlier one of actually going back to the people in a referendum.
Wouldn't that complicated path also deal with one of the issues raised in this petition, which was the invasion of Parliament by security forces?
No.
And which everybody now says, what is the exact message their Lord Justices were sending by saying it was okay to remove members of Parliament using undefined security agents because debate had failed?
I think what needs to be done here is look at that the wording of those judgments. They were addressing a couple of issues here. One, whether or not the Speaker has got powers to discipline or have control of proceedings within the parliamentary chamber. They quoted the law and said she does have.
Yes.
And that's why she's got powers of disciplining.
And that was not in dispute.
Errant members of Parliament. Okay. Of course, it was in dispute. That's why they were making a decision.
No, that was not an issue before them. The issue before them was the use of security.
Now that's where it comes. Yes. That's why they started their argument. So they started there and said, now in those circumstances where you had recalcitrant members of Parliament who were not being able to be controlled or who didn't want to submit to the authority of the Speaker. Therefore, they said that in those circumstances, the Speaker was right. Actually, not the Speaker, but the Sergeant at Arms.
But the Speaker has said, allow Oscar to finish.
I'm quoting what the judges said. And they said in those circumstances, the Sergeant at Arms was entitled to bring in external forces to come in and do what? And bring calm to the situation. What they criticized was the level of force. Okay. Now the issue that perhaps is going to be that is probably going to be debated at the Supreme Court is whether this is not setting up a dangerous precedent or not.
There was a precedent that the preamble talks about. I'm wondering how they reconcile that with the preamble to the Constitution that they were interpreting.
Yes.
Yeah,
In 1966, there was an amendment of the Constitution under circumstances that brought in other players outside that would have required the invocation of the Speaker's powers, that they should have been alive too. At least layman's interpretation was that if you're appreciating the country's history and the arguments presented before them, in the arguments of the lawyers, the lawyers when in their submissions, was you need to look at this in total. You don't need to look at one and say, okay, the Speaker has powers. Yes, she does have powers. If she has powers, what can she do? What can the Sergeant at Arms do? What does this, how does it impact broader constitutionalism?
Can I just add something, Charles?
Yes.
The Sergeant at Arms does not have powers outside of what the Speaker instructs him or her to do, right? The Sergeant at Arms acts on the instructions of the Speaker, okay? So what happened was not disciplining members of Parliament, because the Sergeant of Arms has no powers to discipline members of Parliament. It is the Speaker who disciplines. And the Speaker said, listen, hang on a second. The Speaker said, actually wrote, she didn't know the individuals who had invaded Parliament. She was not aware that the military invaded
I think
Parliament.
the question would be whether that evidence was laid before their Lord Justices as a question for interpretation on the Speaker's letter. Because one of the petitioners, Malema Virize, asked of the court why they had not summoned the Speaker.
To be cross-examined.
I think,
yes, to be
I think I
cross-examined.
want to correct Moses on one particular thing. You see, the disciplinary action had already been taken, right? The disciplinary action was the act of suspending the members of Parliament.
To be out of the House.
That was the disciplinary measure that was taken.
Right.
The members of Parliament defied right, that procedure, right, and chaos therefore ensued. The next, what happened next was what measures were taken to bring order.
And Mr. Kika, yes, thank you for that. And the question for you, for all of you gentlemen, even if you don't discuss the municipal elections, but maybe we'll spare 3 minutes to discuss that. The question then would be, when do you apply separation of powers between the executive
And the legislature.
where those security agencies belong and the legislature, and what does that mean for the broader question of constitutionalism?
I think for me, I want to address the issue of the military. I think this country since 1966 is still going through the baptism of fire of military
rule.
Military rule. I mean, and again, I think it will take the departure of and point X, perhaps for this country to enter into a collegial leadership where no individual, of course, Obode started it. He used to tout Semogero where you are generals. And I think that, of course, even is the basis on which the NRA went to the bush, because partly it thought the military just so that help you take power. So we are still going through the throes of the last vestiges of military control of the state. We haven't shaken them off. And in fact, unfortunately, the country, the population itself loves the military, including the MPs. Now you are hearing the MPs are going to be escorted by soldiers, and they love
by sharpshooters.
during elections, Kisa Besigye has his own mimicking of a military force around him. So we still are trapped in that militarism. And
you see, let me tell you something. For all those who are romantic lovers of constitutional history from a Western perspective, that has not been unique to Uganda. No. You see, in 1789, I think it was still in the first term of George Washington's presidency, right? There was a revolt. There was a tax that had been introduced. I think it's in the state of Virginia or something like that. I stand to be corrected. Okay, and you know, government officials were murdered. So there was a threat to have a second revolution. That state wanted to break away. He had to walk. He was a military general. He had to work with his troops to come and quell down that.
Right now there's a live case of Pakistan where a former cricket legend is becoming a prime minister, and it's allayed only because the military has switched sides with him. So you have in countries like Pakistan,
Charles,
which
no, I'd
are
like
the
to say
same footballs
something.
with
Yes.
Uganda.
Yes.
Silva, if you could just kindly please hold on, because I have a lot of messages and I can hear the phone has been ringing, and I'm reluctant to pick the phone because
I
we'll,
think you should.
we-
You should,
we-
you
we-
should
we'll
pick
have
the
trouble.
phone too.
Gift in Nansana says, thanks for the show. Talking of elections, Gift, we haven't talked about the elections yet, so I will skip that. Now that the additional 2 years for the MPs of the 10th Parliament are no more parts of the Constitutional Court, do we still need the 4-wheel drive pickups and the snipers and sharpshooters? And he says he's asking for a friend. Just a moment, I'll run through these quick messages. Does the preamble of the Constitution still hold, or it also needs amendment? Ask Kika. So I'm putting that to you. So I'll come to you. Sorry, these messages are quite many. I think Mr. Kika argues like a broker. You can't say the judges interpreted the law and not Museveni's will. And not Museveni's.
There's political brokerage.
Josie has come back to us and says Article 1 of the Constitution is redundant in itself. It must be deliberately activated by bringing the people to a point of understanding power and its management. Without that civic consciousness, the whole Constitution collapses at Article 1. Joe Osia in Intina. I need the lawyers to respond to that. Because it is I'll take one more message from him. Yes. To me, the MPs were beaten home and away. They had allegedly put the president at ransom to give them 300 million to lift the age limit, which they didn't get. And after wantonly giving themselves 7 years, they got nothing. They had acted in total antithesis of the spirit of our constitution, and it was incumbent upon the justices to hand back power to the people, since judicial power is derived from the people and is exercised in the name of the people as per Article 126(1). Jose Nwabine. Deborah Sasra says, please allow me add my voice in agreement with honor on how the Constitution of Uganda is born out of our own political history. So the law is not in isolation with the politics. Ask the gentleman why it is always alarming to majority of Ugandans, including the elite, the elite ones, on who is the most suitable to lead Uganda. Mzee does a service and sacrifices to continue serving the people of Uganda out of his unique, noble selflessness to make a great contribution to this country. Why do all leaders get into panic mode and beg him to stand towards elections as the populace stock food items and even go to their villages during voting in fear of Museveni leaving the political scene? Mzee sacrifices to contest. Honor is real. Oscar, how many Ugandans benefit today from the lifting of the presidential age limit? That's from this is Nteja Simwe, is asking. Samo Bo says, I personally, let me say, where does this start from? Yes,
maybe
Milton talks like...
You take some calls, Charles.
Huh?
The phone is ringing off.
I can hear the phone has been ringing.
Like two.
Become unpopular.
Yeah,
Okay.
like some two calls.
Let me take some two calls by popular
The show belongs to the
demand.
people.
Yeah. By popular
The show
consent.
belongs to the people.
Let them have where power belongs.
Hello? Yes?
The show is for the people.
Hello? Hello? Okay. We'll come to them. Silva, you're
Yes.
raring to go.
Yes.
And you need to respond to some of these messages.
Yes, I will.
Hello? I have a caller. Hello? Hello? Please put the number back on the screen so that people can call.
So there has been an ongoing debate here on the invasion of Parliament. I think the most recent example I'm aware of, though it did occur within precincts, in South Africa, at the opening of the parliamentary term about 2 years ago, President Jacob Zuma sent 400 soldiers outside Parliament. Unfortunately, the issue did not go on to court. But I think within the wider scheme of things, I can't look at that.
I have some callers. Sorry. Hello? Hello? Hello?
Hello.
Yes, sir. Your name and where you're calling from?
Yes, good evening.
Good evening, sir.
This is Anton. I'm calling from Chebando.
Yes, Anthony, go ahead. Keep your comment or
Now,
question brief.
About the judgment, this is where I'm having my problem. There were 3 articles which were amended at the same time in Omnibus. So all of them, that was about, we are talking about lifting of the age limit, returning of the term limit, and extending the term of office of the members of parliament. They were voted for at the same time. So we don't know exactly which percentage of the members of parliament particularly voted for each. Now, Mama Mavira said that for her, she was supposed to vote no because her people said no, but she only had to vote yes because of returning of term limits. She wanted that. Now, when you make a judgment and you say that the other 2 are thrown out, where we remain with the problem is knowing whether if those 2 are not involved in the other voting, whether still people would have voted yes, and whether the 2/3 majority that the other bill needed would have come to pass. Because now there are so many people inside there who are just voting because they needed to stay in office for 7 years. If you throw that out, then we don't know whether you have not thrown away the people who actually voted for this particular bill.
Thank you.
This bill does not have a stand anymore. That's according to me. And if I was going to petition, if I was going for appeal, I would tell the Supreme Court that I'm not very sure that this bill got the real vote because some of the people who voted for other things are being thrown out.
Thank you, Anthony. Do I have another caller? Hello? 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 Is there a caller there? Caller, you're silent. We can't hear you. Please drop the call and we'll pick another. Hello? Hello?
Hello?
Yes, sir. Your name and where are you calling from?
My name is Emma.
Yes, Emma.
Hello?
Emma, go ahead. We can hear you.
My name is Emma. I'm calling from Ginger.
Yes, please. Go ahead. We can hear you. Emma, I'm told you're listening to yourself. That's why we're losing you. We can't hear you. Hello?
Hello?
Yes, sir. Your name and where are you calling from?
Hey, I'm Jackson.
Yes, Jackson.
I want to talk to this young man, Kayondo, the lawyer next to you.
Yes, please.
Hey, he's a very young man, but the way he's arguing all things, it's our time, Kayondo, you need to know. These old men has to go. That's the truth.
Okay.
Okay. No, okay. Let me start.
No, Jackson is still.
Right now.
Yes. Let's just speak one more, one or two more. Hello? There's so many people trying to reach us. Hello? Yes, please?
Hello?
Yes, your name, sir, and where are you calling from?
I'm calling from Lira.
Your name, sir?
Gongson.
Yes, please.
Now, I wanted just to see these people to analyze and tell us the other part of the Constitution in the preamble, which clearly states when the Constitution is being overthrown, each and every person in Uganda should stand up to defend the Constitution. Which is standing up to defend the Constitution? Since there's no peaceful transfer of power now, then there's one element left for the people to stand up and do. That is either to use violence or to use the popular power of the people to throw Museveni out. Because it has now remained not as elected government, but they are doing exactly what the military government does. That is to remain in power by the force of the arms, not by the will of the people. So that is where I don't know. As the other judge was trying, the lady justice was trying to say, you can still exercise through elections. But the other part of the Constitution, he didn't emphasize the option that is left to people to take, which are the only 2 options, which is either violence or the popular people to resist Museveni and throw him out.
Thank you. Thank you. There is a message here from Enoch who says, I want to ask Silva of the 3 amendment categories of the articles in the Constitution, a referendum, then the 2/3, where does 5-year term reflection fall? because the final safeguard of elections after 5 years, if it's under 2/3 category, elections too are going to be thrown out very soon. Can I pick one caller? Hello? Hello? Hello?
Hello.
Yes, I hope you're not listening to yourself. If you are, please turn down the volume on your TV set. Hello?
No, I'm not listening to myself.
Yes, sir. Okay, go ahead. Your name and where you're calling from?
Arthur calling from Kampala.
Yes, Arthur, go ahead.
Yes, my only contribution is, why is it that when we are amending the Constitution, we make the amendment to benefit the current, the beneficiaries? Why don't we amend and say, okay, let this amendment take effect with the coming term?
Okay.
So that is my only concern. If the amending the Constitution to benefit the other people who would come in the next terms, then amending the Constitution wouldn't have any problem. But currently we amend constitutions to benefit the guys in power.
Okay.
Yeah, so that is my contribution.
Thank you very much. And we're closing the phone line because we have very little time. I need to come back to the studio. People are still calling, but Silva,
Yes.
you have questions. And someone says you must answer his question on, yes, Silva, please answer the question on those peculiarities, the peculiarities and how they fit into the amendment of 2005, the amendment of 2017, and yeah, this which is 102B.
Okay.
And the preamble of the Constitution.
Okay. Yeah. First and foremost, I've been on record. I'm one of those who are convinced that President Museveni has served his time and we are ripe for a transition. It's not really about just the political leadership. Now I'm leaving law and descending into the arena of politics. And I surely believe, yes, it's our time. The reason, for instance, I'm in court fighting social media tax and digital tax is because I want the same constitutional court to interpret for us digital rights in the context of the Constitution. When the 1995 Constitution was being made, for instance, the internet and digital economy were not yet mainstay as they are now. So I'm there. Now on the other bit of what the peculiarities of those amendments, I side with Justice Kakuru on this, or largely on this matter, and the analysis that he gave largely. Actually, I was for the minority, largely in following that. So you have to look at what still bothers my mind is at the time of consultation, how that 75 age, say, cap was arrived at. For research indicates that in 1995, the life expectancy in Uganda was at 43 years old. 43 years. How? I mean, I don't find justification that the 75-year limit was really an entrenched. It's not an entrenched. It's not an entrenched position.
But Silva, don't you have to look at that?
Yes.
In regard to what you just talked about, the peculiarities and the preamble to the Constitution.
Yeah. So the preamble talks about durability of the Constitution. And to me, that's the bigger picture that we are not looking at. I'm not.
Do you still have?
No,
in as far as when you take out the articles that deal with other general issues, do you still have a durable constitution that can stand as an arbiter to the political question of this country in the way this particular constitution has been handled?
My major critique of this specific amendment is I did not like the way it was done because it was done in piecemeal fashion. We would have loved to see like an entire constitutional review. We've had
could you then answer my question?
Yes.
Given the way the 1995 Constitution has been treated, do you still have a document that you can say this country's future can be anchored on the critical political questions?
Yes. Now you have to understand two things. The Constitution is a document. But beyond it, there is the wider question of constitutionalism. Constitutionalism is that spirit, it's that discipline that keeps the document
Does it
intact.
exist?
So in my view, I don't think constitutionalism exists.
If I may, I think that's what the spirit of that question that was being pushed to my line really was. You know, because I think the person who asked that question was asking it tongue in cheek, saying, look, the constitution was based on the history of Uganda, of this country, right? And the thinking was at the time that because there was chaos because of lack of transfer of power from one peacefully from one regime to another, that's what the spirit of the constitution was. And then come 2005, or whatever, then it is then the term limits are removed. Therefore, the question I think is that, but with the amendment of 205, was it the spirit of the constitution actually destroyed at that time? I think that is what that question was.
Would you answer that question?
I think the constitution is going to be a durable arbiter after Yoweri Museveni. Because look,
thank you.
The way MPs are being treated, for example, has proved that the constitution can be an arbiter. So I think it's a logical necessity of history that this constitution, Yoweri Museveni, predates this constitution.
You
I repeat that point.
Yes, you remember Silva told you that South Africa is into its 6th or 7th constitution?
It's the
6th constitution. So shall we write another constitution?
No.
I think we'll write a new one, just like Kenya. So Kenya had their 1963 constitution. It kept on being amended until 1992 when Moi appointed the single party state. Then you now have a 2010
the much cherished
constitution.
experiment of transfer of power peacefully to another leader is going to happen.
Okay, Oscar, I'm going to come to you because we run out of time. We need to get out of here. So can I have your quick comment also on the elections, particularly the one we'll discuss the politics of the other elections and if this is fate. Particularly the one in Shema municipality and Shema.
Well, first of all, I know you want to talk about FDC. I think FDC.
No, I said I don't want to talk about FDC.
Parties can be an unfair attack when people lose elections. I still believe elections in this country are being largely largely on individual merit. So this idea of saying party X, party Y has lost one, no. It's individuals who are still winning elections. That's why Basalero wins in Buchiri, which I know Yoweri Museveni won. And they win in 2021. So it's not really, there's no linkage between a parliamentary candidate and a party support. As for Shema, of course what it proves is that we don't need so many MPs. Maybe we could actually have a wonderful experiment of this minister continuing representing
the
because the place is so small.
Thank you. Oscar, let me just read this.
Another MP.
Let me read this before you make your closing comment. Charles, I think you people should not rule out the fact that most judges make their rulings knowing the current situation of Ugandan politics and very well knowing that they are still residents of this country. The human nature sometimes overrules the stringent laws. They must have looked at implications of their judgments on tomorrow.
Maybe they talk
We
to their spouses
shall,
before.
we shall always have judgments of ratios 4-1 or the likes. That's Bernard Imperial. And he says, football referees are supposed to be partial. But rest assured, inwardly they have teams they support. And officiating on matches where these teams are participants may call second chance decisions. Bernard Imperial. Make your closing comment. And you can also talk about the elections, and particularly the legal peculiarity that Shema.
I think let me start with the legal peculiarity. I was consulted on this one, and my advice was, after the good MP decided to go and stand, was that the moment he wins the election, he has no alternative but to resign the former seat. So you want to have that peculiar situation where he's holding 2 seats.
I hope he refuses.
If he does refuse to resign, there is going to be there's a minor constitutional issue. And in fact, that action is likely to be.
What is that minor constitutional issue?
You can't represent two constituencies.
Where in the law is that bad?
Places want you.
Okay. I'm told we need to get out. So yes. I'm afraid.
But anyway, but winding up, you see, what the last contributor kind of reflects what practically. Mine is really a cynical view. See, all these discussions that people have, stuff about constitutionalism and when judges sit to make judgments on these things, right? Let me tell you something. Judgments are not made in a vacuum. Judgments are never made in vacuums. And this is world over, right? Judgments are made, you see, ours is a growing democracy, if you can put it as that. Some people not even call it a democracy, but that's what it is.
Thank
right?
you.
Okay.
Thank you. I'm afraid we need to get out of here. Our time is very much. Okay. So just conclude.
And therefore, you will have judges who make the decisions in those circumstances. Peter, I think, put it quite correctly, and I agree with him. You see, as we go down the lane, right, we shall look back at this, as a kind of guidance.
Thank you.
For the ideal in future. Right now, we're not dealing with an ideal situation, and we've got to live with it.
Dr. Kisa, you have Dr. Kisa. There's a message for you here. Council Kika is not discussing as a broker. Charles, the lecturer from the USA, to touch base with the reality on ground in this country. It's not enough for him to depend on what he reads and listens to where he stays. Uganda is not USA. Ugandans understand their politics like Honor regularly educates us. Mzee is still so popular. That's a fact.
I thank that person for defending me.
Please, you have
Charlie,
a few seconds.
Look, increasingly, when I'm engaged in these kinds of debates, I find things rather dispiriting. We have a problem here that Ugandans are going to have to confront sooner than later. You see, you can't be changing the constitution because one individual or a group of individuals want to have a grip on power. And when Peter is talking about the reality is that we are under military occupation. Okay, so let the military just take over power and forget about constitution.
Thank you very much. Thank you very much. Silva,
yes,
you have 20 seconds.
Yes. So I'll make a point. I mean,
please make the point.
Yes. On our side, we will probably not need a new constitution, but I think I read much from Kenya's experience. Coming from the 1963 constitution to 1982 when Moi amended the constitution and brought the single party, then moving on to the post-election violence, and then you have a new constitutional order where 63% of the population voted against what they were calling a Kanu constitution. So the risk is if a majority section of Ugandans begins to see the current constitution as a Museveni constitution rather than the Ugandan constitution, then that will be the tipping point. So I do not think courts are avenues to settle political scores. Let those who want political answers go into the political arena and sort that out.
Thank you. We'll end this discussion on the question of power belongs to the people, Article 1 of the Constitution. Where does that power belong to the people in amendment of Article 102B, but doesn't belong to the people, is interpreted as not having belonged to the people in the amendment of the extension of the term of members of parliament? When do they become representatives in one amendment, in the same article, and when do they become legally? The rules allow them to make certain amendments. That's a debate that will continue, and hopefully the Supreme Court will help define some of these things that will continue to cause debate. I want to thank you, gentlemen, very much for making time for the show. There was one lady who sent a message and said, okay, I'm one of those who is listening to you about your imbalanced panel. I'm watching you, and I've listened to you about your imbalanced panel. So thank you very much, Onapito. Thank you very much, Kika. Thank you very much, Kisa. Thank you very much, Kayondo. Thank you very much to you all our viewers for joining us tonight and always, and for sharing your very valuable feedback on the show. Thank you very much to the production crew that stay up late to deliver the show to you. From me, it's a good night. We hopefully will discuss in more detail the controversy surrounding the Shema municipality election next Sunday. Have a good night.